So imagine a system that's built to settle these massive billion-dollar business disputes in just a few months, not years. Well, that was the big promise of commercial arbitration in Kenya. But what happens when that promise starts to crack? Today, we're digging into why Kenya's fast track for justice seems to be hitting one major speed bump after another.
Let's just put a number on what's really at stake here. That's 33 billion Kenyan shillings. We're talking over $250 million US, all tied up in arbitration cases in Nairobi. And look, this isn't just some abstract legal debate. This is about real money, real projects, and real businesses that absolutely need a justice system they can rely on. When that system gets unpredictable, the economic shockwaves are just huge.
So this really is the billion-dollar question we're tackling today. What happens when the shortcut you built for justice just becomes another long, expensive, winding road? That's the conflict right at the very heart of Kenya's arbitration troubles. All right, so how did we even get here? To really get what's going on now, we have to go back to the original promise of arbitration, a promise so powerful it convinced businesses to completely opt out of the traditional court system. You gotta think of it this way. Businesses were just sick of getting stuck in legal quicksand. They needed a way out of the slow, incredibly expensive court system. Arbitration was supposed to be that escape hatch. The deal was simple: an expert makes a final call, everyone accepts it, and everybody gets back to business. Fast, clean, and most importantly, final. And this commitment to finality, it kicked off what was really a golden age for arbitration in Kenya. The courts made a very clear promise: we'll stay out of it. And that hands-off approach gave businesses the certainty they were desperate for, making Kenya a go-to hub for international business. And this didn't happen by accident. It was a very deliberate journey. Kenya made a conscious choice to move away from the old system back in '68, where courts could just constantly meddle. The 1995 Act, that was a total game changer. It drew a clear line in the sand. And then the 2010 Constitution basically gave arbitration the government's official seal of approval. This was a country that wanted to be seen as a serious player on the world stage. And then came the knockout punch for court interference, the warts and all doctrine. This wasn't just some dusty legal ruling. It was a powerful declaration. The court basically said, look, we don't care if the arbitrator gets a few things wrong. The decision is final, period. This was the ultimate guarantee for businesses. When you arbitrate in Kenya, you get a final answer. No takebacks, no do-overs. But just when businesses thought they had a system they could finally rely on, the rules of the game started to change. The courts, the ones who had promised to stay on the sidelines, suddenly decided to get back in the ring. And that's when things started to get really messy. Yeah, the courts went from being, neutral observers to becoming active players, basically second-guessing the arbitrator's every move. This wasn't just some minor rule change. It was a fundamental shift in the power dynamics of commercial justice in Kenya. And it's a shift that has had massive consequences. Let's break down what actually changed. Before, the rule was simple: the arbitrator's decision is final. Now, the Supreme Court has added this massive asterisk, unless we think it's, manifestly wrong. This move from finality is everything to justice is everything might sound good on paper, but in the real world, it's thrown the entire system into absolute chaos. And if that wasn't enough, another court decision just blew the doors wide open for intervention. The court used this legal loophole called the public policy exception, which is usually saved for extreme stuff like fraud, to overturn an award just because it thought the legal fees were too high. This was a bombshell. All of a sudden, the courts weren't just reviewing the arbitrator's decisions, they were micromanaging them. So what happens when the legal ground beneath your feet is constantly shifting? Well, you get a major dilemma. And this is the real-world impact of that battle between certainty and justice in Kenya's arbitration system. The verdict from the business community is pretty clear. Arbitration in Kenya has become a financial gamble. I mean, can you imagine spending years and millions of dollars on a case only to have the entire decision tossed out by a judge? That's the new reality, and it's making a lot of businesses think twice about investing in the country. The fallout from all this uncertainty is just staggering. We're talking about cases that should have been done in a few months, dragging on for nearly 2 decades. There was one infrastructure dispute that was stuck in legal limbo for 17 years. Businesses are trapped, just bleeding money and wasting time. And this isn't about a few unhappy companies. This is about Kenya's reputation on the world stage. And right now, that reputation is taking a serious hit. So, is there a way out of this mess? Can Kenya actually restore the balance and bring back that certainty that businesses need so badly? Well, the answer might lie in a new set of proposed reforms.
The big hope for fixing this problem comes in the form of a new law, the Arbitration Amendment Bill of 2025. And this isn't just a minor tweak. We're talking about a major overhaul designed to drag Kenya's arbitration system into the 21st century and hopefully restore its reputation as a reliable place to do business.
So, what's in this new bill? Well, two big ideas. First, a specialized court just for arbitration cases. Think of it like a team of legal special forces who know this stuff inside and out. The hope is they'll make faster, smarter, and more consistent decisions. Second, the bill wants to bring the rules up to date with the modern world of finance, making it easier for companies to actually fund their legal battles. These are big changes that could have a huge impact.
So, where does all this leave us? Well, Kenya is at a crossroads. It's trying to find that perfect balance between justice and speed, certainty and fairness. The stakes are incredibly high, not just for the businesses involved, but for the country's entire economy. The real question is, can they thread that needle? Can they create a system that is both fair and fast, both just and efficient? The answer to that question is going to determine the future of commercial justice in Kenya for years to come.